The real property question from February of 2007 is quite an interesting one. Here we've got a hypothetical that poses 4 short answer questions. To my way of thinking, this is not really an essay question. It's 4 short answers, and we've got 15 minutes for each one of them, assuming a 1-hour time limit to complete the exercise. Have a look with me at the call of the question, and you'll see what I mean. Call number 1. Did Lois violate the no assignment provision in her lease with owner? Discuss. Obviously, we're going to have to review that lease and review the surrounding facts. But it's evident that this is the most common issue in landlord-tenant problems, the distinction between an assignment and a sublease. And all you need to know about that issue, I can tell you up front. There is a difference between an assignment and a sublease. In an assignment, the assignor steps out of the picture entirely. In a sublease, the sublessor will retake possession at some point in the predictable future. So that's really all you need to know from a black letter law perspective to answer this question. We've obviously got to look at the facts to be able to tailor our knowledge of the law and apply it to the facts presented. Call number 2. If fast food brings an action in trespass against builder for his use of parking spaces 15 through 20, is fast food likely to prevail? Discuss. One thing that I've told you a number of times is torts and contracts and real property really are just one big subject tied together almost completely, and this is a question that gives you a hint as to why I keep making that argument. These issues are tested together, and the distinctions between torts and contracts and property all blur when we focus on a lot of these essay questions. And here we see that the landlord-tenant relationship is founded in contract, and an action for trespass is founded in torts. So we've got torts, contracts, and property all in play, and we've only looked at the first 2 calls of the question. Call 3. Did owner have the right to change the locks on fast food's premises? Discuss. Well, obviously, again, we're going to have to read the pattern, but my short answer to this question is probably not, because the right to change locks is one that is obtained as a result of court process. And if we've got somebody engaging in self-help, our job almost certainly is going to be to explain why that isn't okay. Then call of the question number 4 brings us back to torts again. Can the homeowners establish a claim for nuisance against fast food? Discuss. We know from torts that there are 2 different types of nuisance, public and private, and that distinction is not a very difficult one to make, but it's one that is relevant in this case. So we've got 4 short answer type questions that appear to be not very much related to one another. In the end, I think what makes this a much easier question, that fact makes this a much easier question than it might be. So let's go to the top of the question and review what happened. In paragraph 1, we meet builder. Builder, obviously, builds this mall and then sells it to owner. A deed from builder to owner reserves to builder the right to use the parking spaces 15 through 20 to sell sports memorabilia and sandwiches on Sundays. What is that right? I would call it an easement in gross, the right to go onto someone else's land held by a person, as opposed to an easement appurtenant where we've got adjoining landowners with a dominant and a servient estate. Now, this is a distinction that those of us who work on the MBE are familiar with. This comes up on multiple choice questions fairly regularly, but hardly ever does it come up on essays, and that's one excellent reason to study this fact pattern. Here we see it coming up on an essay. Now, suppose this is not an easement. What else could we call it? I would characterize this as a fallback position as an executed license. That's a license plus consideration. And the difference between an ordinary license and an executed license is an ordinary license is freely revocable, whereas an executed license isn't. So, in considering call of the question number 2, realizing that we haven't even met fast food yet, it looks as if fast food or anybody else will not have a valid action against builder for trespass. It looks like builder's rights are set out in the deed, and that should be good enough to give him the right to do what he wants to do. Now, have a look at paragraph 2. In paragraph 2, we find out about the lease between owner and Lois. It's a 30-year lease, and it gives her the right to use parking spaces 1 to 20. She pays monthly rent, and she can't assign the lease without owner's prior written approval. She occupies the property for 5 years. Then she subleases the store and parking spaces to fast food for a term of 10 years, and she doesn't get owner's consent first. Is that a problem? Answer, no, because a sublease is not an assignment, as I've already explained. So unless something else happens, we can answer the first call of the question right now. Did Lois violate the no assignment provision? Answer, no, she didn't violate it because a sublease isn't an assignment. And a landlord has got to craft these provisions with care because they will be interpreted strictly. In paragraph 3, we see fast food occupying the premises and paying rent to owner. Okay, we'll stop right there. Owner certainly doesn't have a right to complain about this transaction now because owner has been accepting payment from fast food. So now we can answer the first half of this question. Did Lois violate the no assignment clause? Answer, no. If fast food brings an action in trespass against builder, is fast food likely to prevail? Probably not, based on what we know above. Now, look further into paragraph 3. Here we find out about the possible nuisance claim. We find out that on warm days, when the restaurant is especially busy, the restaurant emits odors. But we get plenty of other important facts too. All of their equipment is state-of-the-art, and they're following all the rules. So, thinking forward to the nuisance action, this is not a constant interference with anybody's right to enjoy land. And as we think also about the possible balancing test, it looks as if the restaurant probably does some social good. They feed people and they employ people. So the nuisance action by the people in the adjoining neighborhood seems to be a comparatively weak one. We look to the end at paragraph 1 above, and we do notice that the neighborhood was there first, before the mall. So a coming to the nuisance defense is not going to work. Probably the best defense would be just to deny that this conduct amounts to being a nuisance. Then, in the 4th paragraph, we get the most complicated set of facts. We see that the first Sunday that fast food is in business, builder sets up his sandwich stand and his memorabilia shop, and a quarter of the parking spaces allocated to the restaurant are taken. Fast food had no knowledge of this in the deed. They complained to builder, and builder basically tells them to get lost, as he has every right to do. Fast food then tells owner that it's going to break the lease, that it won't pay until builder is evacuated from the premises. That's something owner doesn't have the power to do. So owner explains that to fast food, and fast food says it won't pay rent until this is sorted out. And so owner hires a locksmith, changes the locks, and keeps them out of the property. Has he got the right to do that? Answer, no. Just as fast food doesn't have the right unilaterally to cease paying rent, landlord also doesn't have the right to engage in self-help. And then we reach the 4-part call of the question again. And we pause for a moment to realize this is just a series of short answer questions. This isn't a real essay question at all. Almost every other real property question you'll look at is going to be harder than this one. So let's go into an outline of issues and see how we can flesh this out a little bit in such a way as to communicate the bulk of our knowledge as completely and as clearly as possible within time constraints. First, we ask about the no assignment provision. You'll notice right up front I explain the distinction between an assignment and a sublease in its own little separate section. Then I talk about essentially the waiver of any problem by owner by accepting rent, and then I conclude there's no violation of the no assignment clause. Turning to the trespass action between fast food and builder, once again I have a little section about what the law is to explain the theory of liability. Then we go to builder's defense, and here's where we work in a lot of real property law, as we'll see when we get to a quick review of my model answer. And the conclusion is fast food probably loses because builder's deed is good. Next, does owner have the right to change the locks? Well, we start off with owner's theory of liability, which is based on real property law and also the law of contracts, a violation of the lease based on an abrogation of the lease. Fast Food's defense is that owner, apparently, also is in breach of the lease, and fortunately for us, we're not being asked to go into all the different possible permutations of the theory of liability and defenses. All we are asked is the narrow question, has owner got the right to change the locks? And under these facts, our answer is no. Next, we turn to homeowners versus fast food, and here again, my organization follows the same pattern as the earlier organization. I focus first on the theory of liability. First, public and private nuisance, making clear the distinction, and then going into the facts and reaching a conclusion. Probably the homeowners lose. Now, let's have a quick look at my example answer and examine it briefly. This is basically a series of short answers presented in an essay format. The first question, with regard to the no assignment clause. You'll notice that, as usual, I lead with the facts. I explain the relationship between these parties. And there's no reason for us to doubt the validity of the lease. It appears to be binding on both parties. Then I spend 3 paragraphs making a distinction between an assignment and a sublease, and carefully focusing on the facts in the pattern. Here, the sublessor will be retaking possession with 50% of the lease term remaining. So this is far short of an assignment. And next, I focus on the clear fact that owner knew about this sublease and didn't object to it at the time. So because of owner's consent and because a sublease is not an assignment, I conclude in favor of Lois. Lois didn't breach the terms of her lease, and she's not going to face liability for the sublease. Next, we turn to fast food versus builder for trespass, and here I lead with the facts again. I identify the parties and I specify their dispute. Then I go into trespass. You'll notice that I define it. As usual, I don't spend a lot of time defining it, but I do work the definition into the analysis, and I focus our attention on what actually happened in the facts. Then we look at builder's defense. And here, you'll see I spend a fair amount of time on the easement analysis and also on the executed license. In both of these sections, I explain what the law is in about as much depth as I ever do, a couple of sentences. Then I focus on what happened, and ultimately I conclude that the builder has a valid easement in gross to these parking spaces, and fast food doesn't have a trespass action against builder. Then we turn to the issue with regard to changing the locks. Once again, I lead with the facts. I explain what happened. Then I go into owner's theory of liability. It's based on the repudiation of the lease. And here we work in a little bit of contracts law. When one is the victim of an anticipatory repudiation, one has the right to sue now, to wait until performance is due and sue later, or to seek further assurances. When one is the victim of a repudiation, one does not have an instant right to engage in self-help. And that's what owner tried to do here, and we're not going to let him get away with it. Owner didn't have the right to change the locks. Next, we turn to homeowners versus fast food for nuisance. And here, once again, I lead with the facts. This mall was built right adjacent to an existing neighborhood. On warm days, when the restaurant's busy, the neighborhood doesn't enjoy the fumes. Then I focus on the distinction between public and private nuisance, but mostly I focus on the facts. And it seems to me that these facts presented by these potential plaintiffs don't rise to the level of any kind of a nuisance because the interference with their use and enjoyment is not regular. I focus on defenses here to distinguish the coming to the nuisance defense, which is a lousy defense, to the real defense, which is to dispute that this conduct is a nuisance at all. I conclude that the homeowners can't establish a nuisance, and that, therefore, fast food will prevail. And that wraps up a consideration of a real property question that also includes plenty of issues from contracts and torts.